So you have Estelle Griswold, this lady right here, and Dr. C. Lee Buxton, the executive director and medical director of Planned Parenthood League of Connecticut. Both of them were prosecuted and convicted under a state statute that made it criminal to use contraception or to assist or counsel anyone to do so. So this comes out of the state of Connecticut. Estelle Griswold and C. Lee Buxton had challenged the constitutionality of the statute under the 14th Amendment. The Supreme Court, in an opinion by Justice William O. Douglas, overturned their convictions. In doing so, the court had built on precedents such as Meyer v. Nebraska, excerpted in this chapter and on many parts of the Bill of Rights, to develop a broader right to privacy. So this opinion was written by Justice William O. Douglas. We are met with a wide range of questions that implicate the Due Process Clause of the 14th Amendment. We do not sit as a super legislature to determine the wisdom, need, and propriety of laws that touch economic problems, business affairs, or social conditions. This law, however, operates directly on an intimate relation of husband and wife and their physician's role in one aspect of that relation. The association of people is not mentioned in the Constitution nor in the Bill of Rights. The choice to educate a child in a school of the parent's choice, whether public or private or parochial, is also not mentioned, nor is the right to study any particular subject or foreign language. Yet the First Amendment has been construed to include certain of those rights. By Pierce v. Society of Sisters, 1925, the right to educate one's child as one chooses is made applicable to the states by the force of the First and 14th Amendment. By Meyer v. State of Nebraska, 1923, the same dignity is given the right to study the German language in a private school. In other words, the state may not, consistently with the spirit of the First Amendment, contract the spectrum of available knowledge. The right of freedom of speech and press includes not only the right to utter or to print, but the right to distribute, the right to receive, the right to read, and freedom of inquiry, freedom of thought, and freedom to teach. Indeed, the freedom of the entire university community. Without those peripheral rights, the specific rights would be less secure. The foregoing cases suggest that specific guarantees in the Bill of Rights have penumbras formed by emanations from those guarantees that help give them life and substance. Various guarantees creates zones of privacy. The right of association contained in the penumbra of the First Amendment is one. As we have seen, the Third Amendment, in its prohibition against the quartering of soldiers, quote, in any house, end quote, in time of peace without the consent of the owner, is another facet of that privacy. The Fourth Amendment explicitly affirms the right of the people to be secure in their persons, houses, papers, and effects against unreasonable search and seizures. The Fifth Amendment, in its self-incrimination clause, enables the citizen to create a zone of privacy which government may not force him to surrender to his detriment. The Ninth Amendment provides the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. The Fourth and Fifth Amendments were described in Boyd v. U.S. 1886 as protection against all government invasions of the sanctity of a man's home and the privacies of life. We recently referred in Mapp v. Ohio, 1961, to the Fourth Amendment as creating a right to privacy no less important than any other right, carefully and particularly reserved to the people. We have had many controversies over these penumbral rights of privacy and repose. These cases bear witness that the right of privacy which presses for recognition here is a legitimate one. The present case then concerns a relationship lying within the zone of privacy created by several fundamental constitutional guarantees, and it concerns A law which, in forbidding the use of contraceptives rather than regulating their manufacture or sale, seeks to achieve its goals by means of having a maximum destructive impact upon that relationship. Such a law cannot stand in light of the familiar principle so often applied by this court that a governmental purpose to control or prevent activities constitutionally subject to state regulation may not be achieved by means which sweep unnecessarily broad and therefore invade the area of protected freedoms. Would we allow the police to search the sacred precincts of marital bedrooms for telltale signs of the use of contraceptives? The very idea is repulsive to the notions of privacy surrounding the marriage relationship. We deal with a right to privacy older than the Bill of Rights, older than our political parties, older than our school system. Marriage is a coming together for better or for worse, hopefully enduring and intimate to the degree of being sacred. It is an association that promotes a way of life, not causes, a harmony in living, not political faiths, a bilateral loyalty, not commercial or social projects, yet it is an association for as noble a purpose as any involved in our prior decisions. So my favorite part about that opinion was that peripheral. He points out that we need peripheral rights. We need peripheral rights so that way the specific rights that are listed in the Bill of Rights are upheld. So he uses the example of the right of freedom of speech and the right of the press, which includes not only the right to utter and to print, but also the right to distribute, the right to receive, the right to read, and the freedom of inquiry, freedom of thought, and the freedom to teach. Indeed, the freedom of the entire university community. But I also think about the right to petition. The right to petition our government for redress of grievances. We're allowed to show them our petitions and say, hey, 200 people believe that we have a right to use contraception. Well, if you have a right to petition the government, then you certainly have a right to ask the people to sign your petition. And so on and so forth. So our rights, included in the Bill of Rights and the 27 amendments and the body of the Constitution as well as the preamble, don't just include the specific right, but also those peripheral rights that allow the specific right to be actuated. So that's why I like Griswold v. Connecticut, 1965.